appear to have been G, being the notice of motion and affidavit of the seventh applicant.
Yes.
H2. Oh, I'm being corrected that I think we might have gone as far as H2.
Yes, H2.
If you can just determine, Your Worship.
The next one will be then.
After H.
The next one will then be I.
I'm being told I.
Yes.
I or J? J. We skip. Apparently, we must skip I because it does confuse people.
Yeah.
Your Worship, if it's in order with the code, we can go with I, but usually what I've seen is that sometimes I is confused with the 1. That's why I sometimes is skipped. We go to J. But if the code
Okay, no,
is
then
on
it's
the-
fine. Yeah, we can go then to J. You just indicate we have skipped. We are skipping I.
As the code.
Mr.
Yeah.
Namanje, before you sit down,
Yes.
I just want to have the correct,
Yeah.
so that we have the submissions.
Yes, sir.
Yes. So then that one is going to be marked as J1.
Yeah, yes, sir.
No, yes, J1.
And your Worship, you remember that when I rose at the beginning of the bail application, I also handed up the opening statement, and I said on the date that we were making submissions that our submissions must be considered together with the opening written statement.
That is in order.
Yeah, may it be J2 if it was not marked.
The opening should have already been marked.
Was it marked?
Or part of the bundle already.
No.
It's not part of
It was,
the bundle.
no. It was handed up, but we never marked it.
Mark. Can you just locate? Then we need to locate that
I can hand up a copy for completeness.
for completeness.
Yes.
Okay.
And it can be marked as
Just
J2.
a minute, because Mr. Namanje, we have the submissions,
Yeah.
and then you have the case, which is written 1.
What?
This document, because there were, in fact, maybe 3 documents you handed in. We have this, the submissions, and together with the authority.
Yes, that
Yes.
is one.
Bundle.
It must be considered as one bundle.
Together with this.
Yes. We call it the confusion notes.
So the document is then, the submissions is marked then as Exhibit J.
As J1.
We mark it J1, and then the case of authorities, together with the last part, then we mark it J2.
That's the correct J3. Yeah. And the written opening statement, Your Worship, can then be J3.
Okay, then
As the court, please.
then the submissions of Mr. Nomanje on behalf of the first and second applicant is marked as J, Exhibit J1. The case authorities, that is the case of Hamunyela versus Minister of Home Affairs, together with the drawings, the cartoon, so to speak, is marked as Exhibit J2, and the opening statement for Mr. Nomanje on behalf of the first and second applicant is marked as Exhibit J3. Yes. The submissions of Mr. Bangamaba on behalf of the fourth and fifth applicant is marked as Exhibit K.
Exhibit K, Your Worship.
Yes.
You recall we referred to the authorities as contained in Exhibit E1. I think those are marked already. I have relied on the judgment of Hailulu.
That one is already part of the record.
It's already marked as E1. So Exhibit K.
Yes,
that's in order, Your Worship.
Then Mr. Casper, on behalf of the sixth applicant, you have the written submission.
Yes.
And the case of Ace versus Simon is also yours.
Yeah, you can, I mean, it's
just want
principally
to-
that of Mr. Namanje, but for the sake of order, you can keep them with my written submissions, Your Worship.
And then also there's a case of Michael Amushela.
Yes.
Yes.
So
And
those
then
can go
the,
together.
the ruling for
Yes,
Mark
that one of
Betanga.
the very brave magistrate who stood against the pressures of public opinion. Yes, yes, that one, Your Worship.
Before you sit down, Mr. Casper,
Yes,
yes, I
sure.
want us to mark them first.
Okay.
Yes. Then the exhibit for Mr. Casper starts with exhibit K.
No, Your Worship. Yeah,
Yeah.
yeah.
Just a minute.
I know it's easy to say
Okay.
K because it's Mr. Casper, Your Worship.
Yes, so
It
excuse
must be,
me,
yeah,
yeah, exhibit L. The submissions is going to be marked as exhibit L1.
Yes, Your Worship.
And then the authorities, that is Ace versus Simon, as well as Amushelelo case, we're going to mark it as exhibit L2.
It's fine, Your Worship.
And the ruling for Mark Albert Hengari is then marked as exhibit L3.
As the court pleases, Your Worship.
Then the document are so marked.
As the court pleases.
There is still one document. This one appears to be from Mr. Namanje, I think. The specimen for the indictment.
Yeah, yes. It's very important. It can be, because mine with J, it can be J4, Your Worship.
Yes, the specimen is going to be marked as J4 for Mr. Namanje.
Yes, sir.
That is the specimen for the indictments. Yes, we can then proceed.
As it pleases the court, Your Worship, at our last sitting, I was halfway or at the tail end of my submissions in respect of the 7th applicant. I have prepared written submissions, which I beg leave to hand up to the court. I've disseminated them and shared them with my colleagues this morning. Your Worship,
Then
should we-
this document is marked as Exhibit M. That is the submissions in respect of the 7th applicant.
as it pleases the court. Your Worship, I commenced my address at our previous sitting by taking the court through the principles applicable to bail in our jurisdiction. Those various principles. And
You can
then,
just proceed from where we left. We
Is it-
are on record.
as it pleases the court, there's one issue that I should point out that I think we have lost sight of. It's the provisions that are made for in the Criminal Procedure Act in respect of cancellation of bail when an accused person is about to abscond. I highlight this provision to the court because the state is not without a remedy. Should any of the accused persons, for example, not comply with any bail condition, once that is proven, there is a remedy and relief available to the state to rectify such a situation in the event that a bail is granted. Your Worship, I'll proceed now to make the remainder of the observations that I was busy making before we adjourned. And those, Your Worship, you will find at paragraph 65. Paragraph 65. I've already highlighted, Your Worship, that the 4,000 liters, paragraph 65,
6.5.
yes. Key observations start at paragraph 65. I've highlighted during my previous submissions that the 4,000 liters, the equivalent of 3 million Namibia dollars in quantity to be supplied, that the investigating officer referred to as a credit limit, are in fact a quantity of liters and amount per month. It's not a perpetual or once-off 3 million or 400,000 liters. That was agreed upon. So that amount, according to his testimony, was increased to 50 million per month. That then puts to rest the issue of fuel being supplied to petroleum, Erongo Petroleum, in excess of a purported credit limit, because the parties agreed to 4,000 liters per month, equivalent of 3 million, which was later increased to 50 million or 10 million per month. But the point is, it is a per month figure. It's not it's not a once-off figure. So since the amount referred to is found and agreed upon in the fuel supply agreement, if you take
You
those...
are saying 50 million, and then at the same time saying 10 million per month.
Yes, there was a 10 million testimony, I believe, but the investigating officer referred to 50 million.
Now, when you say 50 million, that is because you are saying 10 million per month. I want to see when you are using 50 million.
Yes, 50 million per month.
50 million per month.
Yes, I'll start again. The agreement refers to 400,000 liters, equivalent of 3 million per month.
Because you earlier indicated 4,000 liters. Now you are saying 400,000.
It is 400,000. My apologies, Your Worship. It is 400,000 liters, the equivalent of 3 million per month. That is the quantities the parties agreed to.
Yeah.
That amount was later increased, according to the other applicants, to 50 million. But the point is, the amount is and quantity is a per month figure. And this is relevant and puts to rest the issue of the amount of liter being supplied in excess of a static amount, while this amount is in fact a per month figure.
Yes, just to clarify, because you earlier indicated 50 million
Yes.
or 10 million per month.
Yes.
I want to know, when you are saying 50 million, are you saying 50 million per month or
50 million per month.
Now you also referred to 10 million per month.
In the
So-
alternative.
50 million
Yes.
or 10 million per month in the alternative?
50 million per month, or in the alternative, 10 million per month. The essence of the point is that it is a per month figure.
You can proceed.
Furthermore, Your Worship, in the absence of specific allegations of misrepresentation by the applicant, the supply of fuel in accordance with the fuel supply agreement does not render such supply a criminal offense. Your Worship, the state will argue that it is not required to place actual evidence before the court during bail proceedings. It will point out to the court that it must, through the investigating officer, place before the court the evidence it has in its disposal. And therein lies the problem. The investigating officer did not at any point indicate what evidence is in its possession. He used the word evidence repeatedly, that I can say. But to say we have witness statements, we have invoices, we have delivery notes, that was not placed before the court. It's not sufficient for the investigating officer to simply say we have evidence. He must take the court in his confidence and indicate, without being specific about the number of statements or the names, he must state what evidence is at the state's disposal. The money laundering charge in count 62 against the applicant is simply also unsubstantiated. I've indicated that it is premised on an incorrect allegation of a payment made of 350,000 Namibia dollars by the applicant, as well as a wide overarching conspiracy between different applicants, including applicant number 7. But no information was placed before the court that there is actually at the state's disposal evidence of a conspiracy in its possession. The applicant has already denied that he did not make the payment. He could not make the payment because he did not have those online banking details. This is not disputed by the investigating officer. And in absence of actual allegations of the information pertaining to the overarching conspiracy, the applicant would not have known that the 350,000 Namibia dollars is tainted. But the first point of departure is he could not have made that payment because he had no access to online banking transactions for Erongo Petroleum CC. What is clear from the investigating officer's testimony is that he's drawing several inferences, Your Worship, including an inference of conspiracy. But those inferences are not supported by any facts and are therefore not plausible inferences, nor are they reasonable inferences that this court can draw. The state appears to be inviting this court to draw similar inferences without a factual basis for such inferences, and that is an invitation that the court must decline. Your Worship, at paragraph 71, we make a very important point, and that is that during his evidence in chief, the investigating officer testified that the applicant's role in the administrative operations of Erongo Petroleum CC was unconfirmed by its investigations. He explicitly stated as follows: as to whether he was involved administratively in administering the business affairs, Your Worship, that cannot be confirmed. You will find that at line 30 on page 1266 of the record of these proceedings. Later on, Your Worship, the investigating officer during re-examination then makes a U-turn and says, but there are several sums of withdrawals of money over the counter in the bank from the bank account of Erongo Petroleum made by the applicant, allegedly. There are 4 problems with that prejudicial utterance by the investigating officer. The first one is they were solicited during re-examination in an attempt to fabricate a strong case against the applicant. The second problem is they were not pleaded, nor are they linked to any of the charges against the applicant. Those withdrawals, they are linked to no amount when he made that utterance. The third problem is that it is not, Your Worship, at least not in this country, a criminal offense to withdraw money from inside a fully licensed banking institution, licensed for that very purpose. And then the last problem with Mr. Investigating Officer's utterance about the cash withdrawals or the alleged cash withdrawals by the applicant is that it actually supports the applicant's version that he did not have online banking access details and therefore would not have been able to make electronic fund transfer. So those are the 4 problems with that prejudicial utterance that was made in re-examination. This then takes us to the issue, Your Worship, of the investigating officer's allegation in the state that Erongo Petroleum was owned 100% by the applicant during the period from December 2022 to May 2023.
Just slow down. Yeah.
Your Worship, the parties are at idem on what the BIPA documents state. How the company was started, who was the members, and then what the documents state as to who was 100% owner and when the party ceased. The difference between the two parties is that the investigating officer took the amended founding statement of May 2020 and disregarded all other amended founding statements, including the one of June 2023, where the two remaining members of Erongo Petroleum, it's actually October 2023.
Not June.
Not June, correction. October 2023, where the two remaining members of the close corporation ceased to be members. He decided to rely on the one of May 2020 and disregard the one of October 2023, while the period in question is December 2022 to May 2023. That it is also then factually incorrect. It follows that it is factually incorrect for the state to allege that the applicant was 100% in brackets shareholder in Erongo Petroleum during that period. The next observation I wish to make, Your Worship, is the observation pertaining to the special powers of attorneys. The investigating officer on this aspect was candid in his examination in chief and said he came across a special power of attorney signed during May 2020 authorizing Mr. Austin Alindi to conduct electronic fund transfers on behalf of Erongo Petroleum. The applicant himself produced another special power of attorney, which is attached to his affidavit as annexure LSN 6. That one is dated and signed during June 2022, closer to the period in time. When pressed, Your Worship, as to whether the investigators, given the fact that they were in possession of at least one special power of attorney, whether they then attended to the bank, the local bank branch, to inquire who made those transactions, Mr. Inambao answered that they did not do so. However, in spite of that, Your Worship, the state in count 6C alleges that the payment of 500,000 Namibia dollars to Quality Meat Supplies was made by the applicant himself on 17 December 2022. This allegation is also factually incorrect. It's at odds with the testimony of the investigating officer himself. He conceded during cross-examination that the information in his docket indicates that, one, it's an EFT, an electronic fund transfer, and two, the payment was made from the bank account of Erongo Petroleum CC, not by Mr. Nandawo or from his bank account. The next observation, Your Worship, that we make in paragraph 78 is that during the proceedings, the investigating officer was using the term perpetrators, at least on 2 occasions, to describe the accused persons. And you will find this during the cross-examination by Mr. Bangamwabo at line 20 on page 1551 of the proceedings or the record. However, when it was put to him that he referred to the accused persons as perpetrators, he denied this and responded as follows. I used the word when the offenses were perpetrated. Yes, perpetrated and committed, they are almost, synonyms. He further stated, I called them accused persons, I called them applicants, but I did say when the offenses were perpetrated. You will find that testimony at line 20 to 30 on page 1662 and 1663 of the record. This is worrisome because this is the witness that the state has called to assist the court in conducting this bail inquiry. The witness appears to have changed his version, at least on that point, when the shoe started to pinch. Your Worship, I've alerted the court to the fact that my suspicion that the state in its usual fashion will come and make a lot of the fact that it could not cross-examine the applicant because he moved his application by way of affidavit. I've alerted the court to that. I then referred the court to the Plascon-Evans rule and how it finds application in bail proceedings. I also submitted to the court that there are no material differences in terms of the testimony of Mr. Inambao and the evidence of the applicant that he placed before the court. The state, as I suspected then, provides us with their heads of arguments where they rely on the decision, the authority of Ngipunya, where the court stated that averments contained in affidavits have less probative value when compared to oral evidence which can be subjected to cross-examination. The state is not wrong with that submission when they come to make it, but that's not the end of the matter. Probative value, Your Worship, means for purposes of proof. In this instance, there is no dispute on the facts. What is in dispute is how the investigating officer interprets some of the BIPA documents and the inferences he draws, but on the facts there are no disputes. So the issue of comparing the evidence contained in the affidavit and the viva voce evidence by the investigating officer, it falls away automatically. Your Worship, the second last issue I will deal with is then the concept of the interest of public and the administration of justice. In S versus Gustavo, it was held, Your Worship, and we highlight that at paragraph 83, that when dealing with applications for bail, a court engages in a balancing exercise by balancing the need to preserve the liberty of individuals presumed to be innocent until proven guilty and the interest of due administration of justice on the other hand. By engaging in this balancing process, the court is required to exercise a discretion in deciding whether a person in custody awaiting trial should or should not be released on bail pending that trial. Furthermore, it was held that Section 61 of the CPA, when viewed in its legislative context, allows for a broader approach to the concept of the interest of the public and the administration of justice. In effect, affording the court wider powers to refuse bail in the context of escalating crime, even if an accused has shown on a balance of probability that he or she will not abscond or interfere with the investigations or witnesses. We submit, Your Worship, that this concept is not constituted by opinions of a selected few journalists, especially journalists who were inexplicably present at the scene when accused persons were arrested. That does not amount to in the interest of the public or administration of justice. We further submit, Your Worship, that this concept excludes public opinion and should not be equated to merely public opinion. The concept of in the interest of the public and administration of justice is a crucial concept for considering granting of bail under Section 61 of the CPA. This provision, it is correct, allows the court to deny bail even if it is satisfied that the accused is unlikely to abscond or interfere with witnesses or the police investigation. According to our Supreme Court, its meaning and application is therefore as follows. The concept is wide and difficult to define. It embraces more than just considerations of public safety. It encompasses common law, constitutional provisions, and legislation. The concept was introduced to expand the range of offenses for which bail could be denied, replacing earlier provisions, Your Worship, and affording the courts wider powers to refuse bail in the context of escalating crime. Its purpose is to combat crime and ensure the proper administration of justice, particularly in respect of serious crimes. The rule of law and the principle of accountability require the state to prosecute those who transgress the law without fear or favor to uphold the Constitution. When exercising the discretion under Section 60, courts engaged in a balancing exercise. And in essence, Your Worship, the concept in the interest of the public and administration of justice serves as a broad safeguard to ensure that releasing an accused on bail does not undermine the integrity of the justice system, public trust, or the fight against serious and impactful crimes, particularly economic ones like corruption and large-scale fraud. We submit on behalf of the applicant, Your Worship, that the interests of the public and administration of justice will not be undermined or prejudiced if the applicant, Mr. Nandago, is granted bail. I will now conclude my submissions by saying a few remarks or making submissions on the issue of the relief that the applicant seeks before this court. 2 accused persons have been granted bail in the amount of 50,000 each with certain conditions. Your Worship, we submit that it is not automatic that if you find that Mr. Nandaro, the applicant, number 7, should be granted bail, it is not automatic that the amount should also be 50,000. The court, when exercising the discretion and when it is satisfied that bail can be granted, should consider the affordability of the applicant as pleaded. We further submit that if a court sets bail in an amount so high that the applicant cannot reasonably afford to pay it, this may amount, arguably, to an indirect refusal of bail. The applicant, and this was not disputed, demonstrated that he is a plumber with limited income. He has been in custody for over a month now with no income. Before his arrest, his earnings were limited. Those earnings have come to naught now that he is in custody. He has in his affidavit under oath stated that he can afford bail in the amount of 5,000 sourced from family and friends. The applicant submits without dictating to the court that the court should have regard to those pleaded facts that have been set out in the affidavits when considering what amount of bail should be granted in the event that the court is satisfied that he has made out a good case for bail. In conclusion, and in the circumstances, I submit, Your Worship, that the applicant has indeed made out a case and that he is a worthy candidate to be admitted to bail, and pray that the court should grant the orders as set out in the accompanying affidavit. Another indulgence and a request that I wish to place before the court is that, Your Worship, if the court, given the rights that are in place, if the court is satisfied that applicant number 7 has indeed made out a case for bail, we invite the court to use its discretion to make an extempore ruling, which need not wait for the reasons. The reasons can be advanced later. This is permissible in our law. If the court is satisfied, let applicant number 7 not wait in custody while reasons are being typed. However, if the court is not yet at that point, we accept that the court still has to determine it. But if the court is satisfied that the applicant number 7 has made out a good case for bail, an extempore ruling will be most welcome with the reasons to follow later, given the rights of liberty that are at play and the time that the applicant has spent in custody, as it pleases the court.
Yes, we can proceed.
Thank you, Your Worship. Your Worship, just like my colleagues, I've also prepared written heads which I already advanced to them. But before I proceed, I would like to apply that the submission be marked or be received and marked as part of the record. Exhibit N. Your Worship, there is a case that I would want to refer the
Just a
court-
minute, just a
My
minute.
apologies.
Council, did you receive the submissions by the state?
We received it, Your Worship.
We received this one.
Document that is the submissions by the respondent is then marked as Exhibit N.
Your Worship, my apologies. May I please be excused? I have to be in the motion court. Mr. Namanja will stand in for
It's
me.
in order, Council,
Yes,
you
it
are
pleases the
excused.
court.
We can proceed.
Yes, Your Worship, I was just indicating that there is a case that I would refer this court to later on during my submissions. My colleague is on the way to bring it, but in the meantime, I would like to proceed. Your Worship, the manner in which I would want to proceed is firstly to reply to what has been submitted by my colleagues, then I will revert back to my submissions. I'll start with the following. Your Worship, if the court has regard to page 11 of Mr. Namanja's submissions, specifically paragraph 28, where it says, first, it is easy in a matter in which high-profile accused persons appear and the proceedings are made subject to immense publication by the media. Now, why I would like to start with that aspect, Your Worship, is that the court is well aware of the provisions that is in the Constitution that speaks about equality before the law. And I'm making these submissions saying we do not subscribe to the notion that there is any high-profile accused person before this court. Because to agree to that notion actually erodes the very principle that is in the Constitution that everyone is equal before the law. In fact, we submit, Your Worship, that what does that actually mean? To say the applicants are high-profile accused person, does it mean they should receive special treatment from the court? We submit absolutely no, because they are actually equal before the law as they appear before this court. Just to put that aspect to rest, Your Worship, I would submit that to elevate them to a pedestal that they are high-profile accused persons would not be in the interest of justice, because we agree that, well, they are before this court for the purposes of bail. But what we are saying is that for people who are alleged, and I underline the word alleged, to have embezzled state funds, they should not receive any special treatment before this court. Your Worship, again, I'll proceed to page 12 of Mr. Namanje's submissions, in which he makes reference to the case of Madisia. We take cognizance of that case, but what we are saying is that the sentiments that are actually quoted in that case and find their way in these current proceedings were expressed in a criminal trial. And therefore we are saying the Madisia case with regard to the aspect of public interest and so forth and many other things that we're saying are different from the current case. Your Worship is well aware of the principle of individualization, and we ask this court that when it retires to write its judgment, it takes into account the principle of individualization. Now, Your Worship, the other aspect which was actually dealt with in this application is the issue of arrest. In fact, the investigating officer was cross-examined at great length with regard to the issue of arrest. Now, Your Worship, in our heads, which we will revert back to, we have said a bail application cannot be used as a backdoor approach to challenge the arrest of an accused person. Because we are saying if there was an issue with regard to the arrest of the accused persons, that is a separate issue that can be dealt in a separate case, in a separate court. And in fact, in our submissions, that is on page 6, where we are actually saying the applicants in this court cannot challenge their arrest before an illegitimate court, if I can put it that way, because in a way it's being suggested that, well, the arrest was somewhat unconstitutional, but at the same time they are appearing before this court. So we are saying if there was any issue with regard to the arrest, that is an issue that should have been dealt with in another court. In fact, Your Worship, I would also ask the court to have regard to Section 28 of the Anti-Corruption Act, which talks about the powers of arrest. And of interest, on page 19 of Mr. Namanje's submissions, he has referred the court to the case of Diljan, if I pronounce it very well. And specifically paragraph 9 on that page, on page 19, it talks about the issue that the peace officer has a discretion whether or not to arrest a suspect. In fact, I'll emphasize that the aspect of discretion actually appears twice in that paragraph. So we are saying, although the investigating officer has other discretion to use, such as summon an accused person, and arrest is one of them. So we are saying, even in the case that is being quoted here, it talks about the issue of discretion. So there was nothing wrong in the investigating officer then arresting the applicants or the accused persons that are being court, because he has used his discretion. And on this point, Your Worship, we are inviting the court to have regard to Section 28 of the Anti-Corruption Act, because Those are the powers vested in the Anti-Corruption Commission. Your Worship, I'll move to the other aspect, which was actually I would submit there was a heavy onslaught with regard to that aspect. And that aspect relates to the charges. Your Worship will recall that from the onset of these proceedings, in fact, there has been a lot of words that have been used. In fact, to quote Mr. Namanje, he says, these charges are very weak, they are half-cooked charges, and they are bad charges. Mr. Bangamwabo said, these are weak charges. Mr. Kasper called the charges chaotic and weak. At some point, in fact, he called them pathetic, or weak for the week, 7 days a week. And that is contained in paragraph 21 and 23 of the 6th applicant's affidavit. Now, Your Worship would recall or is aware that at the instance we are seized with a bail application, which is not a trial. And we'll submit later in our submission that all what is required during a bail application is for the accused to be aware of the charges that he is facing. Because we are actually saying, even from the onset, none of the accused persons were actually asked to plead to the charges. In fact, when we commenced with these proceedings, I had actually proposed that the charges be read, but it was actually said, no, there is no need for you to read the charges because it's not a trial. So I'm saying, Your Worship, that on that aspect of the charges being given a lot of names, that these charges are weak, these charges are chaotic, we are saying, were the accused persons prejudiced that they did not understand what charges they are facing? The answer is absolutely no. They are aware of the charges that they are facing. In fact, on page 32 of Mr. Namanje's closing submissions for the first and the second applicant, he has referred to the case of Lamek, in which the judge in that case actually criticized the nature in which the charges were framed. But we are saying, in the Lamek case, that was a trial matter that was before court, in which the judge actually criticized the nature in which the charges were framed. But in the present case, it's a bail application, where the charges that an accused person is facing, he is aware of those charges. There are preliminary charges. If the matter goes on trial, those charges will be amended and correct charges will then therefore be put to an accused person. In fact, on page 30 again of Mr. Namanje's submissions, he makes reference to the case of State versus Hugo, where it was stated that in fraud matters, one has to be precise. Yes, we accept that one has to be precise, but the point we are trying to drive home is that before this court is not a trial, it's a bail application. The allegations that are contained in the charge at least alert the accused person of what charge he will face at trial. And we are saying, when this court also retires to write a judgment, a clear distinction must be made from those two cases, the Lame case and the Hugo case, and that there is a clear disparity with regard to what they actually present, the principle from those cases. Your Worship, there is also just another aspect. This one specifically was addressed to by Mr. Bangamao, in which he says there were contradictions in the testimony of Mr. Inambao. On one hand, he says this, on the other hand, he says this. But, Your Worship, I would like to alert the court to the case of the State versus Amakali Levy, case number CA 38/2008, delivered on 20 July 2009. And in that case, it was said, contradictions do not always mean that a witness must not be believed, but it depends on the nature of the contradiction, their number, their importance, and the bearing of the case, or on the case. We are saying, yes, we accept that perhaps on a few issues, there might have been some inconsistencies or contradictions, but we are saying those contradictions are actually immaterial with regard to the case that is before court. When it comes to the evidence that is before court to show that the applicants are good candidates of bail, those issues were correctly put before this court, and they should not sway the court to say just because there were mere contradictions here and there, then therefore it means that witness should not be believed. Your Worship, there is also another aspect or other aspect that I would like to deal with. Those aspects were dealt with by Ms. Kevin. Those aspects are firstly that relates to firstly bail on affidavit. Correctly so, we have referred this court to the case of Nipunya, which appears on page 3, and it proceeds to page 4. Where it says, and I quote, an applicant for bail therefore cannot be condemned for electing to present its case by way of affidavit and not orally. However, most importantly, it is tried that averments contained in an affidavit has less probative value when compared to oral evidence, which can be subjected to cross-examination. Your Worship, this aspect also goes on to tie to the issue of the sixth applicant, who has also brought bail by way of affidavit. We are saying, well, there are averments or there are points that are raised in the affidavit which has not been cross-examined. They are as they appear, but we are saying the court should look at those as they are stated. But the court should also be alerted or be guided by the principle that was enunciated in the Nipunya case that says an applicant is not prohibited from doing bail by way of affidavit, but it has less probative value. And that is what we will argue in the end. Another aspect dealt with by Ms. Gebhardt is the issue that other two applicants who are not before this court have actually been granted bail. And in fact, it was not just Ms. Gebhardt, in fact, I think it was Mr. Kasper as well. He has said, referring to the Amushelelo case, in which it was said, well, in the Amushelelo case, other accused persons or applicants were granted bail. The court should also consider the principle in the Amushelelo case and be mindful of that aspect. But we are saying, in fact, we should actually be commended for having granted bail to those applicants because we have carefully considered the evidence. And Your Worship will also recall that it was being suggested that we came to court with dirty hands. But we are saying, we looked at the evidence and those applicants were granted bail. So the short of that is that we are saying the evidence as it is now does not mean that there is no evidence against those applicants who were granted bail. But we are saying perhaps to an extent their involvement is different and their circumstances are different from the ones that bail has been denied or bail has not been granted. So we are saying the court again to make a distinction between the Mushelelo case and the case before court with regard to the circumstances under which they have been granted bail. Your Worship, I will move now to address this court in much detail with regard to our submissions as they appear in our heads of argument. Now, just to start with, the court is also well aware of the fact that the standard of proof in a bail application is based on a balance of probabilities and not proof beyond reasonable doubt. And also that an applicant in a bail application is the one that bears the honors to prove that he's a good candidate for bail. That is the starting point. And the guiding principle, Your Worship, is on page 2 of our submissions, where we have referred to the case of the State versus Eugene, which says the purpose of a bail application is not to prove the guilt of an accused, but to demonstrate through credible evidence the apparent strength or weakness of the state's case, and importantly, whether whether an accused is a good candidate for bail. So we are saying, from the onset, Your Worship, if the court can recall, in fact, what we have seen in this bail application is that the applicants have not shown that they are good candidates for bail. In fact, what has been the center of attack is the charges. But when it comes to the issue that this court was seized with regard to whether or not they are good candidates for bail, we submit that to a greater extent that aspect has been absent. Now, Your Worship, there is another aspect that we deal with in our submissions, which actually relates to, it was actually a contentious issue, and we deal with that on page 5 of our submissions, in which it was said, well, this case that is before court in the first place should not have been brought here because it relates to a commercial transaction. Now, as a departing point, Your Worship, I would like to alert the court to the Hamalwa case that I've referred on page 5, which states that, just in summary, that a single act may give rise to both criminal conduct and liability in civil law. The one does not necessarily exclude the other. A misappropriation of property was, as was the case in Castle, gives both rise to crime of theft and civil remedy for damages arising from the same act. So what we are saying is that this argument that is being put before this court that, well, these are weak charges because they belong in a commercial court, are neither here or there, because the court will remember the evidence of Mr. Inamba, the investigating officer, who testified that a certain Mr. Kongoro was actually the one that opened the case with the Namibian police. And at the same time, there is a case that is pending in the civil court. So the argument of saying this is a commercial transaction which should not have been dealt with in this court, we submit, Your Worship, that argument, the court should not even consider it. In fact, I've also referred the court to what Snyman says with regard to the aspect of fraud, that fraud can either be in spoken or written with. And in this case, when regard is held to the asset purchase agreement and the fuel supply agreement, this case is solely based on contracts which are in written form. So we are saying there is nothing that actually stops a party to pursue a case in both criminal and civil stream. Your Worship, there is also another aspect. In fact, this aspect was raised by Mr. Bangamaro and Mr. Kasper. And by that, I am referring to applicants number 4 and 5, and then applicant number 6. That they seek to make a distinction that Namcor, or in other words, Namibia Petroleum Corporation and Namcor Trading and Distribution are separate entities. In fact, they are saying because Namcor Trading and Distribution, a subsidiary of the parent company, National Petroleum Corporation, or Namcor, they are saying, well, Namcor, the parent company, is the one that is a public body, but Namcor Trading and Distribution, the subsidiary, is a private entity, and therefore the sixth applicant cannot be regarded as a public officer as defined in the Anti-Corruption Act. But, Your Worship, I would like to alert the court to have regard to the provisions of the Anti-Corruption Act, which is section 32C, Roman figure 1, which actually provides for what constitutes a public body. And most importantly, it talks about any corporation. In fact, it is important to note that even in the wording of Namcor, it's a corporation. So we are saying the subsidiary cannot claim a separate legal personality from the parent company. In fact, it is common knowledge that Namcor was receiving funding from government. And in fact, from time to time, Namcor would be bailed out by government, including its subsidiary. So how then can it be argued that the subsidiary is a separate entity from the parent company? The law is clear, I'm not making this up. Namcor Trading and Distribution falls under the category of a corporation, and therefore we are saying these entities are one and the same. In fact, Your Worship will recall that during cross-examination of the fourth applicant, he actually agreed that he was the managing director for Namcor, the parent company, and its subsidiary, Namcor Trading and Distribution. But then when it comes to the aspect whether these are two separate entities, and he says, yes, they are. And in fact, just to put this aspect at rest, Your Worship will also recall that during cross-examination, I actually asked the fourth applicant that, are these entities housed in the same building? In fact, he said yes, at number 1 Aviation Road. So we asked the court to take into account that aspect. Now, Your Worship, moving on to another aspect. This relates to the seriousness of the offenses, and that I'm tying this to the issue of the weak charges that are being stated. Your Worship will recall that in our submissions, I just want to refer the court to the correct page. It's page 8, where we have referred to the case of Gustavo, in which it was said, section 61 should not only be confined to crimes, violent crimes, And we are actually saying this is an economic crime that does not, or actually an economic crime that affects the whole nation at large. In fact, we are saying the amount as estimated by the investigating officer, that the amount that is alleged to have been embezzled is an amount of 400 million. And the Ngipunya case, actually, still on page 8, says the days of distinguishing between the seriousness of money-tied crimes and violent crimes can no longer be seen to be different in bail application. Whether the crimes involve public funds or physical attack on a member of society, if the circumstances permit, the seriousness therefore must be taken into account when considering bail. And we are saying, one might argue that, well, it's just money, no life was lost, but we are saying these are state funds that could have been used to develop the country. And we are saying, it was suggested by Ms. Kepat that, well, Mr. Inambao was just referring to, yes, the evidence will show. But we invite the court to have regard to the exhibits that were presented to the court in the form of bank statements of the entities involved. In fact, that will show that this case is indeed serious and that there was a flow of money. So it is actually incorrect to say all what Mr. Inambao said, this evidence will show, evidence will show. In fact, we have presented invoices and bank statements that actually show how money flowed from one account to the other and how each person is implicated in this case. So to suggest that there was only a mere saying, well, evidence will show, no, it is, that is not the correct position. In fact, if your worship has regard to the exhibits, they are already before court. This is exhibit B1 to B10. Those exhibits actually relate to the bank accounts of the applicants in this court. And we invite the court that when it considers whether the applicants are good candidates of bail, to have regard to those bank statements. Your Worship, just another aspect that I want to move to, which is on page 11 of our submissions, that relates to the interest of the public or the administration of justice. Now, Your Worship will recall that in fact there is a document that was submitted by Mr. Namcor, which is actually a drawing or a cartoon, if I may call it that. It should be Exhibit J2 that contains scribbles that actually made fun of how the case is. But I would submit that those are just theatrics that are being employed to paint that our case is weak. And in fact, it is meant to reduce the case to nothing but perhaps a laughing stock, but we are saying these are actually very serious charges. Does the administration of justice in the circumstances of this case actually permit that the applicant should be admitted to bail? Or, by extension, the interest of the public? And again, on page 11, we have quoted the case of Gustavo, in which it was stated that The purpose of Section 61 is to give the court the power to refuse bail, even if an accused has shown on a balance of probabilities that, number one, he will not abscond or interfere with the investigation. But the court is empowered when it considers the interest of the public or the administration of justice to deny bail to such an applicant. So, Your Worship, in fact, what we are saying is that it is actually maybe fortunate or unfortunate that we could also do a small comic to show how actually the candidates or the applicants before this court are actually not good candidates for bail, because it is being made a mockery of what we have presented. And we invite the court that it should actually consider that aspect. Your Worship, on page 12, we have referred to the case of Boyce, where the court reasoned that if an accused is charged with a serious case and if convicted, a substantial period of imprisonment is likely to be imposed, such factor alone entitles the court to refuse bail based on public interest of the administration of justice. So we are saying the court should actually take cognizance of the fact that the amounts involved here are very high, and in the event of a conviction, although we are not at that avenue as yet, but we are saying in the event of a conviction, a substantial time or term of imprisonment might be imposed, and this, if considered, can be an inducement for an accused person to abscond. And we are saying the court should also take cognizance of the dictum in the Boyce case. Your Worship, there is the other aspect, the risk of absconding. And in fact, on this point, there were questions put to Mr. Inamba, the investigating officer, that look, some of the accused persons actually reported themselves to the officers of the Anti-Corruption Commission. So there was no issue of them wanting to abscond because they had known that they are going to be arrested. But Mr. Inamba said, well, they have been called to our offices and they did not know that they are coming to be arrested. And therefore, now that they know the charges that they are facing, the inducement to run or to abscond is very high. In fact, we accept on one hand that most of the applicants have roots in Namibia. They have movable and immovable properties here. But we are saying that alone in isolation cannot be an issue or cannot be an aspect that the court has to look on when it decides whether the applicants are good candidates of bail. There are other numerous factors that the court has to consider. On page 13, we have referred the court to the case of Katsamba versus the state, where it was held that the court has to assess, in assessing the risk of abscondment, the court has to assess the likely degree of temptation to abscond, which may face the applicant. So we are saying the following factors. Number one, the seriousness of the charges and the likelihood of long terms of imprisonment be imposed might be an incentive. We are saying might be an incentive for the accused person to abscond. Just to perhaps closing to the end, there is also the other aspect of the fear that the accused persons will interfere with the investigations and the witnesses. Your Worship, we invite the court to consider the evidence of the investigating officer who actually testified that, look, this case, we are actually still investigating. In fact, to use his direct words, he said we are at an advanced stage, but the court may also take account that he could not give a time frame within which he could finish the investigations. And in fact, if the court would also recall, there was testimony to the effect that accused number 2, I'm aware that he's not an applicant before this court, but when he was arrested, he actually made several phone calls to the others. So we are saying, take into account that the case is still being investigated. What if the accused persons are released on bail? Their likelihood to interfere with the investigations is actually very high. Because we also invite the court to also take into account the evidence of the investigating officer who testified that, well, most of the evidence, not most, part of it has to be obtained from Namcor, from which some of the applicants were employed. And their likelihood to interfere or to influence those people who are working at Namcor is actually very high. I know in reply it will be argued that, well, that is just hearsay, that is just what the investigating officer says. But your Worship is alert to the fact that during bail applications, hearsay evidence is actually admissible. So we are saying, yes, that's what the investigating officer says, but it should not just be said that is just his mere say so. He has evidence with him, and he placed that on record that these people might interfere with the investigations. Your Worship, just to conclude, I would like to make the following remark, that what you have before you, or what the court has before it, is the attack on the charges, but not necessarily sufficient evidence that has been placed before this court to show that the applicants are good candidates of bail. In fact, our argument is that most of the peripheral issues that were raised before this court should not actually even have been raised. The central point or the central theme should have been to show on a balance of probabilities that the applicants are good candidates of bail. But unfortunately, I would say, in fact, 80% of the cross-examination of these witnesses, of the investigating officer, was actually premised on the charges themselves, but not necessarily on the issue whether the applicants are good candidates of bail. And we are saying the cases that have been referred to, just for emphasis, Your Worship, the cases that have been referred to that talk about the nature of the charges, as we have already stated, those were trial matters. I'm yet to come across a case where the court actually made a remark with regard to the nature of the charges during a bail application. Unfortunately, I did not see that. Perhaps one would need to appraise me to see such a case. So we are saying, in conclusion, Your Worship, that the court make a balancing act. In fact, to consider whether the charges are weak as it is being stated, or if there is no case, whether any credible evidence has been presented before this court to show that the applicants are good candidates of bail, and whether they have also discharged the honors that rest on them to show that this court should admit them to bail. And in conclusion, Your Worship, I would like to remark as follows, that it was stated that in one village, the best wine is served first. So we are saying one cannot upload a fish for swimming, because we are saying, well, these are high profile accused persons, then therefore they must be treated in a particular way. But we are saying, no, the court should actually make a balancing act and consider that there are actually not good candidates for bail. Your Worship, just before I forget, there was an aspect that was raised by Ms. Kepa with regard to the seventh applicant. Your Worship would take cognizance of the documents that appear in his affidavit, that is Exhibit G. Those are the BIPA documents that actually it was being suggested that, well, he was just a signatory to the account of Irongo Petroleum. But we invite the court to consider the fact that if the court actually has regard to those documents, they actually show that indeed the seventh applicant was 100% member of Irongo Petroleum. In fact, even on the amended document, it still shows that he was a member. So he cannot distance himself from those documents. In fact, if Your Worship would recall, the investigating officer testified that that's how he got them from BIPA, and he could not change anything. And we are saying the documents actually speak for themselves. There is nothing unclear there, and the uncertainty is actually settled by these documents. And another aspect, it was suggested that, well, the involvement of Mr. Nandaho is less. In fact, that's why it's being suggested that an extempore judgment should be given, or bail of 5,000 should be granted. But we are saying, as per the testimony of Mr. Inamba, he testified that the withdrawals that were made by the seventh applicant actually amount to close to $3 million Namibian. So can it be suggested that, well, his involvement was less, and therefore, just like the other applicants have been granted bail, the two that have been granted bail, and therefore the same should apply to him? We submit not, because the documents actually speak for themselves, and those will be our submissions. Just before I conclude, there is a case I've said that I will submit to the court, the case of State versus Conradi, which we also speak of in our closing submissions, that relates to public bodies and public officers. The court, we invite the court to have regard to that. That will be exhibit, just want to make sure. M2, we submit, we apply that we mark the exhibit M2. Those will be our submissions.
Can the document just be before you proceed? If the document is already falling apart, can we? Yes.
But I can step in. Just step in.
budget is not yet out.
Your Worship, where we are still
Just
on
a
this
minute,
authority.
just a minute.
Yeah. Maybe we expect the state to refer to us and to the court which paragraph of the judgment is relying on. Please, court, Your Worship.
Which in the Conradi case?
Yeah.
Oh, yeah, sure. It's actually on page 37, where the court went into detail to describe what is a public officer. That starts from paragraph 127 up to
It's enough.
paragraph 40.
It's fine.
So page 37, 38, and 39, starting from paragraph 127 to 140.
Mr. You indicated what is the exhibit number?
M2, because my submissions will end with M1. The Conradi case will be M2.
Now your submissions is N.
Yes, it's M.
Yes. The submission was just marked N because there was no indication there was a second one.
Yes. So
Yeah.
it can actually be amended to N1, and then the Conradi case N2.
Councils, do you have the document?
Yes, it's fine.
No objection.
Yes, the submissions by the state is then amended to the written submissions as Exhibit N1 and the Conradi case as Exhibit N2. The court will just take a short 5 minutes break.
Please, court, Your Worship.
We can proceed.
As the court pleases. Your Worship, there is a slight rearrangement.
Just a minute.
Yes.
The IT is still trying to. Mr. Casper?
As the court pleases. Your Worship, you will note that there is a slight rearrangement
Yes.
in the order of proceedings. That is simply occasioned by a travel I have to undertake, as I should be at the airport by 1 o'clock, Your Worship.
It's in order.
So my kind colleagues allowed me to proceed first. Your Worship, we'll keep it short, maybe not sweet, but short. Your Worship, my learned friend for the state has raised the issue of affidavits as has been expounded in the matter of Ingipunya and others. Your Worship, I submit that there is a sound proposition of law. But it requires a little more, Your Worship. You cannot just throw it in there because it's nice or because it makes a good proposition of law. It must be substantiated. And Your Worship, those principles expounded in Hingipunya and others are only applicable in instances, Your Worship, where the state has directly opposed issues contained in a bail applicant's affidavit. Your Worship, you will remember, the state selectively dealt with paragraphs in the affidavits, even when we rose to assess them by directing them to paragraphs to be read in context. I remember my learned friend's words being, I only choose that which I like. Having chosen only that which they like, Your Worship, the state has not directly placed into contest issues raised in the bail affidavits of the applicants, Your Worship. So on that score, Your Worship, you should not take up that invite to yardstick these affidavits on the principles expounded in Ingipunya and others. You will make a grave mistake of law, Your Worship. Now, again, as the IO has done, the state tells us the charges are, well, in so many words, preliminary, because they will be amended and they will then be put to the accused persons. The accused persons have not been called upon to plead to the charges. Bishop, that's not the point. Our law, the supreme law of the land, the Constitution, the CPA, even the common law by extension, Your Worship, tells us when you go about charging an accused person, those charges should be fully explained, not these half-cooked and half-baked charges. But the other point, Your Worship, that this court should not for one moment lose sight of was the invitation by the state. And the invitation by the state goes along the lines that we have a prima facie strong case, and we have put up serious charges. Now, Your Worship, it's almost like a boxing match. Two equally strong opponents come into a ring with a referee. But what the state now wants to do, the referee, is to hold the one opponent so that the state can throw punches. Why am I making this analogy, Your Worship? By implication, the state is telling you and is inviting you as the court to construct a non-existing case for the state. Because now we have taken up the invite and we have seriously demonstrated before this court how weak and, for a lack of better words, Your Worship, pathetic the state's charges are. We have not introduced these charges, Your Worship. It's the state that drew them up. We simply came to this court to demonstrate how bad these charges are. You've also been invited to have regard to Section 32C of the Anti-Corruption Act, Your Worship. And I'd also likewise ask you to seriously consider that. And you will appreciate on the construction of the charges, particularly as it relates to applicant number 7, where the state makes the suggestion that the applicant was a public officer occupying a public office. That Section 32 that you were invited, Your Worship, is exactly the basis upon which we have raised and taken issue with what the state is saying. Because within the four corners of that provision, applicant number 6 does not fall within those confines, Your Worship. You will no doubt appreciate it when you retire to write or make your judgment in these proceedings. So the fact that the charges are to be amended sometime in the near or the distant future does not for 1 second avail the state. What we have before this court and what we are dealing with are these charges that have been provided to us, Your Worship, and nothing else. Now, Your Worship, there is a grave injustice happening here. You will recall, Your Worship, that Mr. Inambao was cross-examined on particularly Mr. Van Wyk, who got bail. He was not forthcoming. He did not want to divulge the circumstances around that bail. And it is now for my learned friend for the state to actually make himself guilty of testifying from the bar by telling you they carefully considered the evidence of, those who got bail, considered their involvement in their circumstances, and they found them to be different. Your Worship, Mr. Inambao had an opportunity. The state likewise had an opportunity to properly introduce evidence that this court could consider. Now these submissions from the bar and tendering of evidence from the bar, Your Worship, should not be received. This honorable court should not even consider it, because it was raised with the investigating officer squarely. And in any event, had the state seriously applied themselves and considered the involvement of the accused persons, as they are saying, as well as the evidence, I strongly submit, Your Worship, that accused persons 6 and 7, applicants 6 and 7 would certainly stand in a slightly different category. But it is quite clear that they didn't also do. So they should not be allowed to introduce things from the bar, Your Worship. Your Worship, this court is not a tool to be used by the state. And when I'm saying a tool to be used by the state, I simply mean in the context, Your Worship, of what has been put before you. And you will no doubt appreciate, Your Worship, when you retire to write your judgment, that what has been placed before this court was as loose as that judgment that my learned friend had given you. It was not held together. It was very loose. It was not connected even to the charges, Your Worship, as a matter of fact. Those charges were not also dealt with the accused persons who testified, or with the investigating officer for that matter. Your Worship, there was the issue raised of a phone call allegedly made by accused number 2, and on the strength of which the state wants to invite this court to make a finding that the accused persons will interfere. But even just on that elementary level, Your Worship, a phone call being made by an accused person to tell others that I am arrested, Your Worship. What is criminal about that? What about that amounts to an interference? And you will no doubt appreciate, Your Worship, that accused number 2 was even arrested a day before all the other accused persons. Surely, Your Worship, that should not be a consideration at this point. There is nothing that precludes. In fact, he even did it in the presence of the investigating officers, Your Worship. He did not hide. And they knew he was calling other accused persons. Also, Your Worship, insofar as it relates to the interference with witnesses and the likes, again, my learned friend for the state finds himself submitting from the bar. But that investigating officer who stood in the witness stand there, Your Worship, was also thoroughly cross-examined on the aspect of witnesses. It was suggested to him, which he considered, although under most difficult circumstances, that he did not disclose to the accused persons when they were charging them who the witnesses in this matter are. Yet, my learned friend for the state wants to tell you these are Namcor employees, and I presume it's against those who were equally also Namcor employees that suggestion is being made, that they ought to know who the witnesses are, Your Worship. But the fact remains, Your Worship, that the accused persons are not privy to a list of witnesses. Your Worship, those would amount to my submissions in reply, unless there is anything this court would like me to specifically address.
It's in order, Mr. Casper.
As the court pleases.
I will be brief, Your Worship, in my reply on behalf of first and second applicant. When my colleague for the state stood up to make submissions, I expected that he would be able to stop the case of the state from further bleeding. It remains bleeding. It's bleeding all over. Doesn't stop bleeding. And I will demonstrate in a reply. Let me start with what my colleague started with, and that is at page 12 of my heads of arguments, or rather, page 11. We never suggested, as my colleague submitted, that our clients are high-profile accused persons. Somehow they must receive some special treatment as far as public opinion is concerned. We never made such submission. The submission under paragraph 28 of our heads of argument is general in that it is easy in matters in which high-profile accused appear and the proceedings are made the subject of immense public publication by the media for a court to seek to satisfy public expectation. So it's a general observation, and we have to back it up, and I wish, as a matter of law, to hand up an extract, Your Worship, from an important judgment, and that is S versus Nombeu, 1996, Volume 2, SACR 396, E in bracket, Your Worship, and I give my colleagues copies. And Your Worship, the copy, the extract that you got, may I invite the court at page 428 of the law report, which is the second page. And we are highlighting this because there is danger in Namibia in a society where...
My document says page 423, not 428.
Yes, 423, Your Worship. And Your Worship, before I quote the quotation from Makwanyane judgment, the important judgment of Makwanyane in South Africa, may I just make this observation? It's frightening in a society such as Namibia, 35 after independence, that on fundamental and basic human rights entrenched in the Constitution, you find, even more frighteningly, lawyers, leaders, past and present, would make statements that are inconsistent with core values in our Constitution, such as representation of accused persons by lawyers, presumption of innocence, and so forth. And these few individuals or persons with statements that are clearly unconstitutional always act in a manner that is constitutionally primitive. And that is the reason why I quote from at the bottom of paragraph B, Your Worship, from that judgment quotes from Makwanyane, where the court stated the following: the court should in fact endeavor to educate the public to accept that a fair trial means constitutional trial, and that includes bail applications and vice versa. Pronouncement on human rights by the courts and academics obviously add body to the jurisprudence which surrounds the Constitution. But the abstract statement of law very often mean different things to different people, and very little to the bereaved and aggrieved, who see factually guilty accused go free in consequence of some infringement of his constitutional rights by officials enforcing the law. It is therefore the duty of the courts in their everyday activity to carry the message to the public that the Constitution is not a set of high-minded values designed to protect criminals from their just deeds, but it is in fact a shield which protects all citizens from official abuse. They must understand, that is the public, that for the courts to tolerate the invasion of the rights of even the most heinous criminal would diminish their constitutional rights. In other words, the courts should not merely have regard to public opinion, but should mold people's thinking to accept constitutional norms using plain language understandable to the common man. So that's what the message and the submission we made. So we never said all what we said. We must not have a situation such as it happened in the case of Judge Tiag, And the Supreme Court made it clear that Justice Tiek was not properly handled because of his high-profile status. That's the point we made. Then, the Madisia judgment that my colleague referred to at page 12 of our heads of argument, Justice Liebenberg obviously made those statements in a trial, but they are equally applicable to bail applications. It doesn't matter. It's the same. I don't know why my colleague had to refer to understand our arguments out of context. Nothing further need to be said about that argument. Then, this is the injustice we meet every day in court. When you make an argument and a colleague misunderstands it entirely, we made it clear at the beginning of this bail application that we are not attacking the validity of arrest. However, we were showing to this court as a factor in when you exercise your discretion that in the first place, the arrest was not necessary. Because, your worship, if you find that the arrest on the fact was not necessary, then it will follow that that person who was arrested when it was not necessary can never be remanded in custody after bail application. So my colleague misunderstood us. So we say, if you find that it was on the fact and the law, the arrest was not necessary, that it is a factor in exercise of your discretion. And your lordship, your worship, you referred to the judgment we referred in our heads of arguments. That is the Minister of Home Affairs versus that is a judgment just from, I think it's page, let me just find the quotation. Yes, page 19 of our heads of argument, paragraph 36. That is Dillian versus Minister of Police. With greatest respect, again, my colleague is with respect, utmost respect, off mark. We never said and we could never have made such a submission. We never said that case is an authority to the fact that you have 4 choices. All what you need to do is to exercise a discretion and pick one. That's not our law. Why is my colleague avoiding Hairuru? Hairuru is our judgment. Hairuru stated that because arrest is the most invasive one, is the most grave one in terms of the effect on the liberty of an individual. When you exercise the discretion, arrest is the last thing you must apply. You must first consider something less invasive. That's what we are saying. My colleague appeared to have understood us is like at an auction where you just tick off, I want that bull or whatever heifer. That's not what we said. So we were misunderstood. And with greatest, let me come to the charges. My colleague is in pain, and I can understand. And the self-inflicted pain. Why is he complaining up to today? He had the reservoir of power, energy, facilities, and people around him to fix this problem before they dragged my clients to court. And he did not. Now he's telling you the correct charges in future may be properly brought before court. He's wrong. And he said, maybe because of audacity of confidence, he said, I have never come across a case in a bail application where the Namibian court said that charges must be properly framed for purposes of bail. We care less if he hasn't come across such a case, but there is one we refer to. Why did he refuse to consider it? It's S versus Unengu. So, Your Worship, I was sweating around here, referring to a number of cases, including Unengu. My colleague was not following. Unengu, paragraph 6, Your Worship, and it's not obiter. It was the ratio of the judgment, because in that case, Mr. Unengu attacked the fact that the charges placed before the magistrate in the bail application did not meaningfully inform him as per the elements of the offenses. So it was the issue to be decided by the High Court in a matter relating to bail appeal. Justice Ndou in the High Court, few meters away, under paragraph 6 to 8 of the judgment, Your Worship, I provided the court with a citation in our opening statement, I think, and I will ask my juniors to file a copy after today's proceedings with your clerk, Your Worship. Stated that an accused person, even in a bail application, must be meaningfully informed of the case of the state per charges relative to the elements of the offense. What is my colleague trying to do? Your Worship, look at count number 36, for instance, to give you an example. Count number 46 against Mr. Peter Elindi. As an example. No, it's 38.
Not 36.
Yeah, 38. D2. Remember when I cross-examined Mr. Inambao, he continuously lamented, but we deliberately pretended we couldn't hear him because we care less, because he's the one that dragged our clients to court. Lamented that these charges were preliminary and will be... That charge, he considered that it's wrong because a charge under section 46 of the Anti-Corruption Act, conspiracy, must be in relation to a charge under the ACC Act, Your Worship. But the state, confusingly, and very, very weak, in a very weak manner, relied on something else in a manner inconsistent with the act. And I want to give you, because they relied on fraud. Fraud is not an offense under the ACC Act, Your Worship. And I want to give you an example, a simple, not dramatic example, just to drive the point. Your Worship, if an accused comes here on a charge of murder, which is a Schedule 1 offense, and the state relies, as they usually sing, on public interest, but the charge is saying, on this date in Windhoek, Mr. B.D. killed, an element of murder is a human being, but the judge put a baboon. Your Worship, you have thrown that case out of court already in a bail application. Using a crude language, you would have, with respect, stated, state, are you serious? So in other words, it doesn't matter. When you are bringing to court people in a bail application, Your charges must be in order. So now, even today, my colleague, not with confidence, I was looking at him. He says, Your Worship, the correct charges are coming. So the converse of that is that the incorrect charges are before you. The half-cooked charges are before you. But then he invites Your Worship to refuse bail on those charges when he concedes they will never be there in future. Reminded them that the courts are not sangomas to have this foresight, what charges the state will in future prefer against the accused person when they are ready. This is a serious matter, Your Worship. So they want to turn you, Your Worship, into a judicial panel beater. When you retire to panel beat these charges and somehow treat them judicially and legally so that your judgment is appear to be on the basis of a correct charges apparently in future. Doesn't work that way. So we are entitled. How can it be? If the Constitution requires me at the arrest to be told the ground promptly and fully, that's what the Constitution is saying. When you arrest somebody, you must be in a position to tell him the ground of arrest. And the ground of arrest, Your Worship, for your notes, is in two respects. The first one is in relation to what is a criminal offense. And you must say it meaningfully, rationally, and neatly. You must say it. The second one is that arrest is necessary. It's the ground. Why are you arresting me? You must say, it's because I fear you will not come to court if I summon you. None of this happened in this matter. Probably because it's a high-profile matter. And with greatest respect, it had that my colleague will still in argument go on with these 480 million figures. It's not acceptable to stick, even the investigating officer, Your Worship, I cross-examined him. He didn't. As far as my clients are concerned, how can the prosecutor bank and rely on this, rely on this figure when the investigating officer ran away from it? It's bad. So don't blame us if you have bad charges. Then don't arrest people. Then my colleague referred to the case of Hugo. S versus Hugo, Your Worship. Yes, I knew the state will not fail to refer to this case because it is against the state. Hugo case followed in many judgments in our jurisdiction is the fact that in a fraud matter, you must be precise. That is the standard, minimum standard. For many years. In fact, forever a century. So now, when that is considered with our constitutional value, you want us to relax judicial standards on how you accuse people of fraud. My colleague possibly forgot that he's in a magistrate court that cannot undo or upset judgments in the High Court. In fraud matter, you must be precise. These charges are all over. Today, in this agreement, to the other day, that offer, that whatever. The dynamics only changed when the bribes were paid honestly. My colleague may laugh at my cartoon and notes. They are a perfect example of this case. In fact, in Ambao, came to court to tell us evidence, not this cocktail he was telling us, a cocktail of inconsistencies, contradictions, and contradictions, yo. Then there was reference to the issue of bail to other accused person. Yes. For Ms. Lydia Elindi, the court has a slight indication, possibly, and why possibly? Because I want the state. Remember, Your Worship, it's on record. Once she testified, I said, soon somebody will account in malicious proceeding. Then comes an agreement, we will grant bail. But another accused person, Your Worship, there is no public accountability. We don't know why he was given bail. My colleague cannot testify from the bar. Your Worship, you do not know this thing of saying the less involved, but all we know, they are in the same case. Schedule 1 offense, Section 61, public interest they relied on, we do not know. So now the public, what have happened in the days since he was given bail? What has public interest done to show that a release of Mr. Elindi would jeopardize administration of justice? In fact, it is against the state, like in Amsherero's case, because the court was never informed through evidence why the other person got bail. Accountability and transparency would have required the state to account in this bail application to you, Your Worship. Otherwise, the state will be beaten by the Amsherero judgments and others, Your Worship. And again, there was another injustice to our arguments. We never submitted that a commercial transaction will never give birth to criminal charges. That's never our submission. What we said on the fact of this case, what happened, if anything, maybe a breach of agreement. On the facts of this, it's a commercial dispute. That's what we said. So one must honestly, because we were the applicant, we are the dominatus litis in this matter. The case is ours, but you cannot distort it. This is not some biblical submissions where you have freedom to say this or that or that or that all over. This is submissions in court relative to issues identified by the parties. I'm just checking my notes if I finished everything.
Take your time.
Yes. And there was a reference to one of the accused persons having made a call, as I understood, as a basis to say all other accused, assuming that call was a guilty call. Since when are the accused person made to suffer consequences of someone else's action? Since when? But when we had evidence, there was even nothing strange about a call. There is no law in this country that prohibits an accused person or a suspect or a person being arrested to make a call. In fact, the law does encourage accused person to get in contact with lawyers, with family members. There's nothing wrong. And this is the sad part of it. of people who investigate crimes in Namibia. Many of them and their judgments, including, Your Worship, the judgment of Simon Tuafeni was part of the judgments I handed up in one of the bundle, where police officers do not even know the basic requirement of arresting a person. So my clients can never be refused bail because a call was made by someone else, Your Worship. And lastly, public interest argument. I think this is abused. Your Worship, I was pleasantly struck by the manner in which Justice Simasiku, acting judge, handled the public interview of judges recently before the Judicial Service Commission. You would recall that he bravely, when he was asked about the judgment of the High Court in Hipunya matter on bail, on the constitutionality of the amendment to that section, he said that he answered and said no, he preferred the Justice Masuku's minority judgment on the constitutionality, and we know that he was appointed. I'm not saying he was appointed because of that answer. I'm just saying, when we say, I'm talking about legal practitioners now, not lawyers in general, but I'm talking about legal practitioners who have taken an oath, public prosecutors who have taken an oath and are carrying a delegation by the prosecutor general, and judicial officers, both in the lower court and the high court. We all have a special duty towards the Constitution. So he defended that public interest must not, it's not an abstract concept, so that, Your Worship, you say, like in Ambao, conceded, and remember, Your Worship, I submitted that he will never, as a matter of law, escape the concession he made when I was cross-examining him. He said, my clients were never arrested because they would run away. They would interfere. They are danger. He made those concessions. Someone in WhatsApp groups where a lot of confusion is on those groups, even just listed all those concessions. As far as I am concerned with my clients, those concessions are there, common cause. Now, when you refuse, assuming the court is refusing bail, public interest must somehow be linked to some kind of prejudice or jeopardy to administration of justice. But if Mr. Inambao, in trying to play with this council, he's trying to not make concession with some legal practitioners, he's making concession. The fact of the matter is, he simply demonstrated and supported my client's case that it is in public interest that they be released on bail. So we showed with everything that we could that the state has a weaker case. As I said, its case is bleeding all over. We did everything to point out. The record is clear. In fact, I was reading the transcribed record now. I could not believe how bad the evidence of Mr. Inambao was. If my colleague is relying on that evidence, then we may as well just give judgment in favor of everybody on any evidence placed before us. And lastly is hearsay in bail application. My colleague is wrong. He's wrong. It's not that bail application hearsay is admissible in bail application. Why did he stop? I have authored a small book in which I refer to the leading case on hearsay. It is hearsay evidence is admissible if not disputed. My colleague stopped because he feared he will lose the case if he completes the sentence. I just completed the sentence for him. The principle is hearsay in bail application is admissible if not disputed. That judgment has never been upset and is repeated in a judgment called, Your Worship, in S versus Amunyera, Silvanus Amunyera, by Justice Siboleka, yes. So it's not good to start cutting legal principles because you fear losing a case. Those are my submissions. With greatest respect, like others, I submit that the case has been exceedingly been made out in favor of the applicants for bail. And as I said, because of the poor nature of the case, even a warning will not be out of place. Those are my submission replies.
Yes, Your Worship. I will be very brief. I will try to avoid any temptation to rehearse what my two colleagues have referred to. I will refer Your Worship to the written submission by the state, the written submission by fourth and fifth applicant, as well as the two judgments, basically the judgment of Hailulu, just to endorse the submission by Mr. Namanje. I will refer to paragraph 92 of the same judgment, which is binding and also which involved the Anti-Corruption Commission. And it's very clear that the Anti-Corruption Commission, either they are bad listeners or bad students, because whatever time they are given a warning, they don't listen and they don't want to follow the proper law. Paragraph 92 of that ruling is very clear, Your Worship, meaning that you only arrest if it's necessary. There was no evidence before this court that the arrest was necessary. Number two, we never challenged the validity or the legality or otherwise of the arrest, because no single relief, no single applicant sought a relief or an order in terms of which the arrest must be reviewed and set aside. There is no such relief by either of the applicant. So the submission by the state that we are challenging arrest is misplaced, is not supported by any evidence by either of the applicant. And then on the issue of high profile, fourth and the fifth applicant, Mr. Mulunga and Jennifer Mukwaya, when they testify in the evidence, in the chief, Your Worship, none of them termed himself or called himself or herself a high profile accused person. We don't know where this is coming from. We say in our closing submission that this case has been termed fuel road. We say there is no such thing. This is just a sensation being created by some obscure forces to create a public outcry and maybe ensuring that the accused person or the applicants who are presumed innocent remain behind bars. And then we said one of the grounds for refusing bail being advanced by the state is the seriousness of the charges against the accused person, against fourth and fifth applicant. the seriousness and the amount involved, Your Worship. That's why we have to deal with the charges in details. Your Worship, we, as far as the fourth applicant is concerned, Mr. Mulunga, questions were put to the investigation officer. Why did you arrest Mr. Mulunga? Saying he pretended to have authority to sign asset purchase agreement. When the investigation officer replied, said, no, actually he had authority to sign even for 500 million. And then, of course, we say these are weak charges. Actually, not only weak, they are bad in law. They can't stand the test of legality. And then I asked, you provided so many bank statements, more than 10, of both private and juristic entities. How come you never provide the bank statement of fourth and fifth applicant? Your Worship will recall, it's clear on the record, his answer was, oh, we are still investigating them. I pressed him until he said, no single cent was received from any of the retailer or the entities listed in the charges. So why did you arrest them? Oh, because of conspiracy. And then I say, you see, Your Worship, that's it, the last point addressed by Mr. Namanje. You are alleging conspiracy, common enterprise. In other jurisdictions, they call it criminal enterprise. But why are you releasing other people who are in the same criminal enterprise? Why did you release Connie? Why did you release Lydia? We are not saying it's a bad decision, but the state must be consistent. Your Worship, when you were a student in the first year, law student, what is the meaning of law? Law, one of the characteristics of law is consistent application. You can't apply one law to A and then to B a different law. That will not qualify as a law, Your Worship. We submit that when the state made the decision to release Connie and Lydia, who are co-accused in conspiracy or criminal enterprise, they actually should have immediately, they should have stopped opposing bail in respect of the remaining applicants. They should have withdrawn their grounds of objection. That would have been the best decision, not to prejudice the other applicant, to spend the whole month here arguing, paying legal fees. Some of them are mothers, their kids are staying with the nannies, the kids can't do homeworks, the kids get sick, they can't be taken to the hospital by their own parents. We say the state is stopped from persisting with their objection in the light of the release of the two co-accused persons in this saga. Now, my colleague says our clients, we refer to fourth and fifth applicant, they are not good candidates for bail because they are being accused of embezzlement of public funds. Really, Your Worship? Embezzlement of public funds? After the investigation officer himself said no single cent was received in their bank statement. Public funds, Your Worship? I asked the question to Mr. Nambao. The Namcor Trading and Distribution entity, it's a private entity. It does not receive a cent from the government. Does not receive any levy. That was testified by Jennifer Mukwaya, who was the then chief finance and administrator, who is in a better position than anyone, including the state counsel as well as the investigation officer. He says no. Government does not give any cent to that entity. So how can you say now we are dealing with the public funds? My Lord, Your Worship, apology. I called Mr. Nambao, Nambao, ACC as a debt collector. Why did I say that? Because the claims, the charges arising, the circumstances and the facts around these charges arose from contractual agreements. I don't want to repeat myself. I've referred this, Your Worship, to Basic Principle, Article 21, and we say, look, no one challenged those two contracts. No contractant. Namcor and the buyer and the seller, they were all happy. No one raised the issue of misrepresentation. And we say because of privity of contract, ACC has no capacity to interfere with a legitimately concluded contract. Mr. Nambao said, yeah, the asset purchase agreement, the fuel supply agreement were legitimately concluded documents. It's clear on record. He says he had the problem with what will happen thereafter. Your Worship, Mr. Inambao, I can't blame him. He's not a trained lawyer, but I don't understand why the state, as trained lawyers, cannot come and tell the court the argument by Inambao is absurd. It's strange. It's a bizarre argument. The moment you agree that a contract was legitimately concluded, the fruits are legitimate. As simple as that. The money paid were purchase price. And I demonstrate to the court that they could do whatever they wanted with that money after they performed in terms of the contract. So whatever happened thereafter, Your Worship, I think with due respect, Mr. Nambao and the state, they are confused and they try to confuse the court. Now, the next issue before I close, Your Worship, is the issue of this case of the case being referred to by the state. They did not read the case properly, unfortunately. The case is not applicable to the present fact. Conradi, the state versus Dek, Conradi, and another. And when his worship is penning his judgment, I will invite his worship to look at the paragraph 136 up to 141 of that judgment. It's clear. Judge Masuku, next door, he says who penned this judgment. He said MTC can be regarded as a public entity. Why? Because it's owned by government. 60% shares are government and 40% by members of the public. That's very important, Your Worship. 40% government and 60% government and 40% members of the public. It's there. But Namcor trading and distribution, who are the shareholders? It's just another private entity. The government has no single share in trading and distribution. No member of the public has a single share in Namcor trading and distribution. So, with due respect, and of course, MTC gets money from government. Namcor trading and distribution does not get a cent, no evidence before this court from the government. So the case cannot help the state submission. And I will submit that, of course, it be declared distinguishable from the facts before this court. Now, the state into submission says the contradiction by Inambao are minor. They can't be minor. Yeah, the record speaks volumes. Mr. Inambao was asked during cross-examination on behalf of fourth applicant, I said, my client is a victim of witch hunt. He did not commit a crime. He said, no, it's not witch hunt because I never met Mulunga before I went to arrest him. When later on, of course, because he's not a reliable witness, because maybe he's malicious, he says, yeah, I know you used to drive that car because me and my colleague, we used to drive spying on him. How do you spy on someone you don't know? That contradiction cannot be minor, Your Worship. But also, Your Worship, when you say, I asked him, you obtain a statement from a certain Kamati Heleni. Yes, where is the statement? Oh, it was not necessary. Where is it? We want to know what Heleni said about the car. I went to Natis to investigate Mulunga's Audi Q8. What did you get from Natis? Nothing. Mute. Zip. Where is the certificate of registration showing ownership of the car? Nothing. I went to the bank. Mr. Inambao, what did you get from the bank? Oh, I know the car was bought on HP, hire purchase, and I know the last installment has not been paid. Why don't we have those documents from the bank? The question was, I put to you, you are withholding that evidence because that evidence exculpates fourth applicants. What is your comment? No comment. So, Mr. Inambao is not a reliable and credible witness, and his evidence must be considered, must be approached with caution. I'm finishing now. Now, we say, Your Worship, they say fourth and fifth applicants are not good candidates for bail. It can't be true, Your Worship. When they took up the stand, they showed that they were aware of the charges well before the arrest. They never went anywhere. There is no evidence that they are flight risk. They say we can't interfere with witnesses we don't know. There is no evidence that we ever interfered with any investigation. And Jennifer Mukwaya said, I'm a mother of 3 minor children. The kids are with a nanny. And in terms of Article 15 of the Constitution, those children have a right to be cared for and protected by their parents. None of the parents is available because both herself and the husband are in custody. And on that, I will refer the court to the judgment in Peterson versus the state. It's a high court judgment of South Africa, the Cape of Good Hope Provisional Division, and I will give you a copy to his worship, but specifically at the paragraph 63 of that judgment, where the court says that it was a bail application involving a lady who murdered the husband and the father of children. And during bail hearing, Your Worship, one factor which was relied on by the applicant was that the 8-year-old daughter was a minor. Once the mother is not given bail, the minor child will not be protected and cared for. And the court in paragraph 63 said, when, as in the present case, the circumstances relied on by the accused include the constitutionally protect the interests of a minor child, the court must, not may, in terms of section 28. 28 is the equivalent of 15 of the Namibian Constitution. Take cognizance of the child's right to family care and parent care, or to appropriate alternative care when removed from the family. And then, of course, the court referred to another case of MS versus S, where the matter before the Constitutional Court of South Africa also insisted that when an applicant is a parent of a minor child or minor children, that factor must be taken into account when determining bail. So I submit I would do seek leave to hand up a copy of that judgment, and I will make sure that I make available to the state after this procedure. To be that judgment can be marked as exhibit. My submission were K. Was it K, Your Worship? I think it was K. That can be K1. K1. So, Your Worship, I submit that today.
Just a minute. Yours is K.
K, so that can be K1, Your Worship.
Any comment? No, it's in order. Yes, the document is then marked as Exhibit K1.
Please, the court, Your Worship. So, in conclusion, Your Worship, I submit that as per the evidence in chief, read together with the submission in support of bail application, that the fourth and fifth applicants have made out a case for the relief being sought in their bail application, and the court is invited to grant bail in terms of any condition it may deem appropriate in the interest of justice. Please, the court, Your Worship. Unless there is any question or issue for clarification, that's it for in reply.
It's in order.
Please, the court, Your Worship.
It's almost, and I know that I want you to take your time. I don't want you to rush. Only?
My points are only on points of law, very brief.
You can proceed.
As it pleases the court. Your Worship, the state appears to be offended or shocked when the charges are being examined in a bail proceedings, and they are taking the examination of those charges as criticism.
Maybe before you proceed, just for the record, the judgment for Nangwa Peterson versus the state South African case dated 27 February 2008 is marked as Exhibit K1.
Please, the court, Your Worship.
As it pleases the court.
You can proceed.
Yes, Your Worship, the points that the applicants, and particularly the seventh applicant, has taken in pointing out the deficiency of the current charges, not the future charges, the current charges on which the applicant was arrested, is because of the fact that this court must make the determination to grant bail, taking into consideration the strength of the case that the state brings. So, if the charges are deficient, it follows that the case for the state is weak. You cannot have a strong case on deficient charges. That is the purpose. It then further follows that since the case is weak, the incentive for abscondment becomes zero. That is the purpose. It is not to criticize the state's drafting. It is to deal with the issue of the allegation of risk of abscondment and seriousness of the state's case. And for that authority, we rely on, for that submission, we rely on the authority of S versus Ngipunya, where the court said the question whether the appellant is likely to abscond is closely linked to the apparent strength of the state's case and the resultant sentence to be imposed. That's the first point. The second point in reply is simply to emphasize that our court is very clear on what the correct approach is when one is dealing with the allegation that there is a risk of interference. It must be whether the appellant will interfere and not that he may or he or she may interfere. And for that submission, we rely on the authority of Shidu versus the state and the judgment of Justice Liebenberg. The next point I wish to make is the issue of the interest of the public and administration of justice. It is not enough, it is very little, it is not adequate for the state to simply make that statement and say the interest of the public and administration of justice will be prejudiced if any of these accused persons or applicant are granted bail. The state must go further and say because of 1, 2, 3, 4, and 5. The state has failed to do that. What is it about applicant number 7's release on bail that will likely prejudice the interest of the state, of the public and administration of justice? The state has failed to do that because that is the exercise the court will have to conduct in terms of considerations of section 61 of the CPA. The last thing I have to do, Your Worship, is of service to my colleague, Mr. Namanje, who has referred to the matter of Unengu versus the state, and that is to, with your leave, hand up the judgment. The specific paragraphs have already been referred to.
Unengu case is not in Mr. Namanje's bundle.
I
think we ended with J.
Yes, I'm just saying that it's not in your bundle.
Not here.
I know I appear to have only quoted it, but not handed up a copy, Your Worship.
Okay.
As the court, please.
Your Worship, it is then on that basis that we submit.
Before you proceed, any comment, Advocate?
No, Your Worship, it's in order.
What is the number?
I think Namanda was J4.
Do you want it to be part of Mr.
J5
Namanje?
now.
J5 now.
J5, my lord. The last point.
Just a minute. Yes, exhibit J5, that is, just a minute. Yes, exhibit J5, that is the Unengu versus the state case, is marked as exhibit J5.
Yes, Your
It's
Worship,
part of Mr. Namanje's exhibits.
yes, Your Worship, there are a number of general statements that my colleague, my learned friend for the state made in his submissions, that he made of general application to all applicants without any specificity, even when it doesn't apply, for example, to Mr. Nandaro, the 7th applicant. Especially, and I single out one, the reference to people in higher positions or high-profile people or persons. My client specifically pleaded before this court that he's a plumber with meager earnings. He never submitted, and it was never put, and it cannot be put to this court in submissions that he is a high-profile person. Not that that is even an issue that this court should consider in any event, as it pleases the court.
The court will have to reserve judgment to apply its mind to the issues before court, complex and also voluminous record before court. and the court is considering taking into account other factors. The court is considering the date 26 September, that is for judgment.
There is no earlier date, Your Worship, given the nature of the proceedings.
Yeah, there is no earlier date. The court has looked at the diary. That is the most appropriate date.
Maybe if something happens, then the judgment is earlier than that date. We will be
The
informed.
court cannot promise because I have other pending judgments,
Yes,
other
the court,
pending.
please.
Please, the court, Your Worship.
There is not
Yes.
much we can do.
Yes. The date is,
It's in order.
yes, 26 September, that is for judgment. Applicants, you are in custody. The matter is then adjourned to 26 September.
As the court, please.
Please, the court, Your Worship.